Please take your seats. We're about to begin again. Well, we've lost a lot of our people, haven't we? Well, Harshberger's back there in the back. There's Fat. Pushkin should be here. I saw him a minute ago. Let me know when you think we got a quorum. We got 3 up here, 4, 5, 6, 7, 8, 9, 10.
Yeah. Not like John. Once again, reiterating, not like John.
I think we should. Yeah, I was just making jokes. I mean, it's all public record. It's all public record. So I think we should. I've already told her to do that. I think that's exactly.
For what?
I see what you did.
Apparently we lost a lot of people to eating. Moot.
Yes, ma'am.
Had to move around the desk.
Okay, thanks. Okay, bye.
We'll call her. Committee, please come back to order. We've returned from recess. We're starting again with another portion of the Legislative Auditor's Report. Counsel, will you call your next witness?
Yes, Mr. Chairman. The committee calls Mr. Robinson back to the stand.
Mr. Robinson, you're still under the same oath?
Understood.
Please proceed.
Mr. Robinson, we're going to be dealing basically with a portion of your second report, Report 2, that deals with the use of purchasing cards by the Supreme Court of Appeals, actually by subordinate bodies of the Supreme Court under the court's oversight. Could you explain generally for those who are unacquainted with them what the P card or purchasing card is?
The purchasing card is a credit card issued by the state auditor's office to entities of state government to allow them to purchase items using a state issued credit card, which the state receives some rebate benefit from doing so with.
How is that use managed, generally speaking?
In general, the P cards are issued to individuals, specific entities, and there is a coordinator that oversees the purchases on each purchasing card, to which those purchases at the end of a month prior to that billing for those purchases being paid are reviewed by the P card coordinator, who essentially approves the transactions contained within that billing.
And that coordinator is within that, for lack of a better phrase, subject department or branch or division.
Yes.
And they have to approve it. Now, does the state auditor's office also have to oversee the use of that?
Yes. Once the initial transactions are approved by the P card holder and the invoice is then submitted for payment to the state auditor's office, the state auditor's office also reviews those transactions before paying those.
So there's essentially 2 layers of review on every single purchase, ideally speaking.
Ideally, yes.
And is that governed by statute, by rule, by policy? Where are the authorizations for how that program is administered set forth?
The state auditor's office issues its state auditor's office purchasing card procedures and policies, to which all entities utilizing the state purchasing card must follow.
Does the court itself have any explicit internal policies and procedures that regulate P card usage, to your knowledge?
Not that I'm aware of.
So it's basically all under the fairly uniform rubrics that are promulgated by the auditor's office.
That's correct.
Do you happen to know how many P cards were assigned to the court itself?
I do not.
Based upon the information contained in the report, is it your knowledge that each of the various probation offices in the state had a P card that was assigned to them, at least?
Yes, that's correct.
So each county has a probation office within it, and so there were at least 55 cards that were the subject of the investigation that you undertook.
That seems correct.
What was the issue with the court's use of the card in the instance cited in the report?
In the instance in the report, we noted that the Supreme Court of Appeals, through their adult drug court and probation offices, were utilizing the purchasing card to purchase gift cards as incentives for the adult drug court participants as part of an incentives program to be provided to those participants in order to aid them in completing the steps of the program and giving them some incentive and recognition in doing so. What was the second half of your question again?
That was it. And so, ideally speaking, what these probation officers were to do was to go out and to use these to purchase gift cards, which would then be issued to the participants in the drug court program.
Yes, initially the program in terms of the purchase of gift cards was meant to provide small dollar amount incentive gift cards to actual participants, but that evolved into something else.
So to give a hypothetical, and just to confirm that this is an instance of the sort that would have originally been intended by what you were informed by the overseers of this program, a probation officer in, let's say, Hampshire County could go out and buy 50 $20 gift cards to use at McDonald's or at or to buy movie tickets or to or for a store or other entity.
Yeah, it's my understanding that the gift cards that were awarded directly to the participants were of a low value, often well under $50, but I understand $50 may have been the maximum amount actually incentivized to an individual participant.
So this was the sort of purchase that was supposed to have been typically made with the P cards by these probation office personnel.
Yeah, and that's correct.
So who supervises the use of the P cards for the courts?
The overall supervision of all P cards?
Yes, sir.
I would believe the Director of Financial Management has some duty in overseeing the use of all purchasing cards, but also there is some direct authority for the individual P card coordinators to monitor the use of the P cards by the individuals they're issued to.
So the folks within the counties themselves were supposed to exercise some degree of oversight and management.
That's correct.
And then they would have their purchasers reviewed at the level of the court itself, which would then be reviewed by the auditor's office.
That's correct.
Okay. Was prior approval, and I think you've answered this, but I want to make this clear, so prior approval for these purchases was supposed to have been obtained from the auditor?
Yes, based on the P card policies and procedures from the state auditor's office, any use of a purchasing card to purchase a gift card as it is a cash equivalent item must have prior approval for each instance of a purchase by the state auditor's office prior to the purchase being made.
And that was not obtained within the instances detailed in your report?
No, it was not.
And I believe if we'll look on page 9 of report number 2, you have 118 instances where there were purchases of drug court gift cards over $100.
That's correct.
And none of these were authorized prior to purchase by the auditor's office.
That's correct. They were not approved prior to purchasing.
And it appears that there were 94 of some value between $100 and $499.
That's correct.
20 for values at between $500 and $999.
That's correct.
And 4 for $1,000 gift cards.
That's correct.
And my understanding is, based upon a review of the documents that you provided to us, which we have not attached as an exhibit simply because we have not found a way to make it visible to the committee because it's in an extremely minuscule typeface, that this was, something on the order of 500, and there were actually 118 instances over $100, but there are, I think, 500 and some odd purchases.
Yes.
Most of which were in the sub $100 range, but there were, as detailed within your report, 118 over $100.
That's correct.
And so the concern, I believe, is detailed in your report, is that these large dollar, we'll call them these $100 plus, these large dollar gift cards, there's no mechanism that is available to oversee what is done with that gift card once it is purchased.
No, I do not believe there was an effective system in place at the court system or within the probation offices to accurately account for the spending of the value of the gift cards that were of large denomination.
So hypothetically speaking, one could purchase a $1,000 gift card and use it, as we detailed in the example, to buy 50 $20 gift cards.
Yes.
But there's no record generated of that purchase that appears within the P-card system.
Some adult probation offices or probation offices for the adult drug courts did attempt to maintain receipts for items that were purchased with the large denomination gift cards. We attempted to reconcile a batch of receipts concerning use from one gift card by the Kanawha County Adult Probation Office, and essentially we could not reconcile it back to the full amount of the gift card value.
And when you say you could not reconcile it to the full amount, could you estimate for us what percentage of those funds you were unable to account for?
In reality, we really couldn't provide any assurance to any accounting of any of the funds because the disparity of the receipts didn't list out proper detail to differentiate which gift card had been used, because oftentimes there was a large gift card purchase that was running out and then they had another large gift card behind it to which they purchased other stuff. So it was almost impossible to reconcile it back to one individual gift card.
And so these cards, these high dollar cards, were basically used to buy items or other cards, and usually other cards for the drug courts was the intention that's been communicated to you.
I wouldn't necessarily say it was usually for other cards. It was to purchase incentives for the drug court participants out of that. It was done so out of a matter of convenience because as it was told to us by the court, there is only one purchasing card issued for each adult probation office, and therefore only one individual at those offices authorized to use that card to purchase items using the card.
And as you noted, there's no way to monitor what these purchases were that were made using these high-value gift cards.
Not under the methods that were being employed by the court at the time.
And so they could have been used to purchase any number or type of goods and services, but you have no ability to present that information to us as to what that might have been.
That's correct.
And while these purchases were ostensibly made to be used to purchase items and gift cards for use within the confines of the drug court program, thus we actually have no mechanism by which we can prove that they were so used.
That's correct.
Are there penalties for the unauthorized use of a P card?
Yes, it's my understanding that unauthorized use of the P card can be subject to revocation of P card privileges for that P card holder.
Is there a criminal offense for persons using a P card with unauthorized?
I'm not sure of that.
Okay. When did you, as the legislative auditor, become aware of the issues that were surrounding the use of the P cards?
Ultimately, it was through the media reports from WCHS and Kenny Bass that identified the issue to us.
Approximately what time was that?
I want to say the article ran earlier in 2018 between the months of January and March. I can't be specific, though.
And you conducted an investigation, and I believe the date of the second report that was issued somewhat subsequent to March of 2018.
Yes, I think the second report from our office was issued in May.
And you sent a letter that is marked as Exhibit 17. There it is. And this was sent to Judge Johnson, who at that time was administrative director of the courts. And I believe that this letter notified the judge of the problems that were accruing with the use of this P-card system that was in place at the time.
That's correct.
And it recommended to him that the use of the P-card as it was currently being used at that time be discontinued.
That's correct.
And that is a result of the investigation that you developed that is chronicled and summarized in report number 2 herein.
That is also correct.
And just to make clear, if we could go back to Exhibit 16. And if we can go into number 4 on Exhibit 16, I believe that is the 3rd page of Exhibit 16 is where that starts. And then we'll go to the 4th page, which actually has the language we're looking for. In sub F, it appears that all purchases made for the adult drug court program must be made with a state P-card, and that the P-card login receipts were to be due on the 10th day of the month, and that there were supposed to be logs and receipts that were submitted to the courts to confirm all of the purchases that were made utilizing this system. Now, was that system followed?
Yes, in terms of the purchases made using the state P-card, those receipts were submitted to the court, reviewed, and approved, and that would be because the only item that showed up on the purchasing card receipts was the purchase of the large denomination gift cards. If that was the case, anything used or purchased subsequently with that gift card was not accounted for through that P-card log.
So the court was reviewing and approving these large value gift card purchases, even though there was no mechanism in place by which they could account for what was subsequently done with those large value gift cards.
It's a fair statement.
And I have nothing further at this time, Mr. Chairman.
Thank you, counsel. We'll start back on the left side. Delegate Fast, questions of Mr. Robinson.
Thank you, Mr. Robinson. Thank you, Mr. Chairman. Just looking at this page 8 of the second report, what is the authority for the purchase and payment of incentive supplies, graduation ceremony matters, participant meals and snacks? Is that a statute?
I'm unaware if it is a statute.
Okay, I'm just trying to find out what the authority here is. Another says currently incentive purchases are limited to $1,000 per month for each probation office. Where'd that come from?
I believe that policy was established internally of the court.
Okay, so that's, again, that's not a statute or anything?
Not that I'm aware of.
Okay. Each probation office is issued one purchasing card to make purchases with, including to purchase incentives needed for drug court participants. Same thing, that's just a policy.
I believe so.
So is this, it looks like this is perhaps a colossal failure to recognize what the state auditor is saying, that you just can't do this without the auditor approving these purchases. If that is the case, is there any particular Supreme Court justice that is implicated for these alleged violations of P-card purchases of these incentive amounts?
I wouldn't say there's any particular justice. There's no particular justice, no.
Okay, just the court as a whole?
The court as a whole, yes.
Okay. And is that, so that's the whole issue here, it's not a particular justice?
That's correct.
Thank you. Thank you, Mr. Chairman.
Delegate Foster.
My question on these cards, and I don't know if you all delved into this at all, but is there an area where the majority of this was done, or is this something that was done at, because it was done by the each individual office? Is there somebody that was a prime offender in these purchases? Was it 529 of them, I believe?
No, we did not note that any particular county or probation office was a prime offender in utilizing this methodology of purchasing large denomination gift cards.
So it was pretty much throughout the state?
Yeah, as I mentioned, it kind of became a common practice as a matter of convenience for them to get around the stipulation that the P card holder and that there was only one for each probation office was authorized to make the purchases, which made it difficult for them to stop their daily duties. And this is the court's take on this, but if they were tied down with other duties, they couldn't leave to make purchases that were needed. So in order to get around that, they purchased the large denomination gift cards to which anyone could utilize that to make purchases.
And what was it? Was it actual gift cards for specific vendors, specific stores, or was it like a Visa gift card that they just used wherever?
Both.
Both. And did this all start, like, because there's multiple agencies throughout the state, it's just surprising that it would start all at once equally throughout the state if it didn't come from somewhere upper in the Supreme Court system.
You know, it may have been a decision made by, and this would be speculation and I hate to do so, but it could be a decision that was made at one probation office and then was followed suit throughout the rest.
So you're not sure if it was something?
No, not at all.
Okay. All right, thank you.
Delegate Sabonia.
Thank you, Mr. Chairman. On page 8, under issue 3, it says in 2016 and 17, you all found that the drug courts under the Supreme Court of Appeals purchased the gift cards. Was that just the time that you audited, or how long had that been in practice?
I can't say how long it's been in practice. Essentially, this was what was identified by the state auditor's office per a FOIA request from WCHS News concerning this purchase, and essentially re-requested that FOIA documentation as well. That was provided, which was only covering the calendar years 2016 and 2017.
So this could have been going on for even longer than that?
Possibly so, yes.
Okay, and you said that the Supreme Court authorized those P-card purchases. Was it the justices that signed off on it? Was it the Supreme Court manager, the administrative manager? Was it the financial officer? Who actually did the authorization of that?
I'm not certain. I do know that any P-card transactions that are made by a specific holder, there is a coordinator that oversees that holder's transactions. That coordinator then signs off on those transactions at the end of the month. Then that ultimately is passed up to probably someone in the Supreme Court's financial management office, to which it would be approved there. The individual doing so I can't speak to.
Okay, and then just to follow up on the gentleman to my right, his question about are there certain county probation offices that stood out more so than the others. In the table 3, it indicates that there were 4 $1,000 cards purchased. You can't tell what county probation offices that came from?
I possibly could. I just don't have that information available right now.
So that's something that you could get to the committee members?
Absolutely.
Thank you.
Back to the second row. All right, we'll move to the right-hand side, beginning with Delegate Taslow. No. Delegate Pushkin.
Thank you, Mr. Chairman. I'm looking at, I put on my glasses, I can see what I'm looking at. Page 8, I believe. I'm trying to see where I saw it just a second ago. The money that we're talking about, it doesn't come from taxes paid by our constituents, right? It would come from the participants in the drug court?
Yes, the participants of the drug court programs actually pay into a fee, and that is where these funds are derived, not state tax dollars.
Okay, so I guess the issue is they didn't ask permission from the auditor to do this, but it's not that we're dealing with tax dollars, we're dealing with fees who are willing participants in the program, correct?
That's correct.
Okay. And do you have any idea how much it costs to house one of these participants in one of our regional jails or prisons for a day?
Off the top of my head, no, but I want to say daily inmate costs are somewhere around between $40 and $50, if I'm correct.
And that would be tax dollars, correct?
That would be, yes.
Okay. No, I just wanted to get it across that these programs save, not only do they save lives, but they save money. And I've been to one of the, have you ever been to a drug court graduation ceremony?
I have not, sir.
You have not?
I have not.
Okay, I've been to, I try to go to all of them. I recommend other members of the committee attend, and it's a good program. Thank you.
Delegate Lane.
Thank you. So none of this money for the purchases of these gift cards comes out of state dollars?
The only instance where state dollars are used to pay for incentives in any type of drug court program is the juvenile drug court program.
Okay, but did I not read over on page 9 that although the drug court participants are supposed to be paying, that some of the counties haven't haven't paid everything that they're supposed to pay?
Could you point me more directly to the comment?
Page 9.
Last paragraph, possibly?
Yeah.
Well, interestingly enough, what happens as a result of the adult drug court policies regarding the use of funds to be spent on incentives, each drug court office is limited to spending $1,000 per month. In some instances, either drug courts collected more than that per month on a consistent basis and it accumulated a balance, or they weren't spending as much as other drug courts and had a remaining balance that was somewhat substantial. I think, as we noted in here, Hampshire County had over $60,000 in collected drug court participant fees that had not been used.
So they collected it, but it hasn't been used.
That's correct.
Okay, thank you. Now, okay, that's all I have.
Delegate Fluharty. Nothing. Delegate Byrd.
Thank you, Mr. Chairman. Thank you for being here still. Just one question is, do the P cards have an individual's name on each one per county, or is it just says Hampshire County P card? I'm not sure.
Oh, no, it's issued to an individual.
Each county?
Well, each P card is issued to an individual, so at each county there would be an individual at the probation office that the P card was specifically issued to.
All right, thank you.
Back to the third row. Delegate Robinson.
Thank you, Mr. Chairman. Mr. Robinson, did this program come at any direction of any of the justices under impeachment proceedings today?
No, I believe that the mandate that each county operate a drug court, and I can't speak to the incentive program specifically, but I do believe the mandate to operate drug courts came from the legislature itself.
So this program that has been cited in your report here has nothing to do with Supreme Court justices other than the fact that they are over drug court and all other courts in the state?
Yes, that's a fair statement.
And that nothing to do with the 5 justices we've been tasked to investigate today?
I can't speak to the relationship anyone else could draw to the program and the justices.
Okay. Did the drug courts quit this practice as soon as the auditor pointed it out?
The drug court stopped the practice of purchasing large denomination gift cards once we had issued the letter to Gary Johnson identifying the issue and that it needed to cease until such approval was granted.
So as soon as it got identified, it was shut down?
Yes, and our concerns with the program was simply lack of accountability and the lack of approval for these transactions from the auditor's office.
And would the court typically rely on the auditor's office for expertise in spending and those kind of things?
How so?
As in, a program like this, if it's not appropriate, would they rely on the auditor to point it out if that purchasing or P card purchase is not appropriate?
I think the auditor's office can identify particular transactions that may not be appropriate, but as in terms of whether the program and the purchases made for the program and the program itself, I don't think that's the state auditor's office's call. I think that was something done by the court.
Okay, thank you.
Delegate Hanshaw.
Yes, Mr. Chairman. Mr. Robinson, I know that some members of our Supreme Court of Appeals have taken varying levels of interest in being personally involved in the administration of the drug court over the years. Can you help me understand how the spending is monitored? Is it monitored in the first instance by the circuit court judges? As I understand the program, it's administered at the local level first by the circuit court judges.
Yes, I imagine that the particular transactional level data is scrutinized more closely at the local level, and then more at a higher level as the overall program by the Supreme Court offices here in Charleston.
But in terms of actual approval of programmatic design and use of funds and carrying out of expenditures and actually giving direction to those who are working on the ground, and I don't know, does that come from the East Wing, or does that come from the Circuit Court judge?
I don't have that answer either.
Okay, thank you, Mr. Chairman.
Delegate Fleischhauer?
Thank you. Thank you, Mr. Chairman. I think in the answer to the first question, you said that no particular Supreme Court justice has been identified as being a problem with respect to this program.
No, I don't think any one particular justice was intricately involved in any activities regarding this program, no.
Okay, so there was, and also there's nothing to indicate any of the justices committed any crimes in conjunction with this P-card program or these incentives?
Not that I'm aware of.
Or that they lied about anything?
Concerning this particular issue?
Yes.
No.
Or that they did anything immoral?
No.
In relation to this? Okay, thank you. Thank you, Mr. Chairman.
Mr. Robinson, I want to just conceptually visualize this. You said that each county got a P-card.
Yes.
So that one person in that county had some authority up to $1,000 a month to spend on that P-card.
At least in relation to each county's probation office, that's correct.
Okay. And the Supreme Court, but I thought you said earlier the Supreme Court was not issued any P-cards.
You asked if the justices specifically were issued P-cards, and no, they are not.
So the Supreme Court had how many, the court itself as a body had how many P-cards?
I can't answer that question outside of the fact that for each county probation office there would be at least one P-card, so it's likely to readily assume that there's at least 55 for the probation offices.
So how do they get those P-cards? Does the Supreme Court request P-cards from some other entity and then they're distributed to the counties based on that request?
The request would be made to the state auditor's office, but the authority to request them probably would come from the Supreme Court, but I can't be certain of that.
But I thought part of the problem was they didn't ask permission.
They didn't ask permission specifically to purchase gift cards using the purchasing card. Any purchase of a gift card using the state purchasing card requires prior approval of that transaction for each instance of a purchase, not as a whole.
So they didn't need permission to issue the card. They needed permission for the card to be used to purchase gift cards.
Yes.
Is that correct?
Yes, and the purpose for that is accountability and transparency. Essentially, once the gift card's purchased, the only thing that can be tracked through the purchasing card program is the purchase of the gift card, not what is subsequently purchased with the gift cards.
You indicated that the drug courts were essentially required of the Supreme Court by the legislature, correct?
That's our understanding from the Supreme Court.
Did the legislature require the Supreme Court to have P-cards issued to each drug court?
No, and the P-cards aren't particularly issued to the drug courts. They're actually issued to the adult probation offices.
Did the legislation that the legislature passed require that, or was that a discretionary decision by the Supreme Court?
No, the purchasing cards were already being held by the adult probation offices for day-to-day purchases using the purchasing card outside of the drug courts or the incentive program.
So then the problem was someone gave authority to the drug courts to use a P-card they already had to purchase gift cards. Is that right?
I'm not sure that anyone gave them authority to, but it's possible.
Well, how did this program then start where they weren't purchasing gift cards before and suddenly they started purchasing? How did that?
I'm unsure of the inception of this this methodology for purchasing large gift cards.
Well, was the Supreme Court aware that that was going on?
To my understanding, yes.
They were. Okay. And so they're aware of a process by which these P cards were being used by their probation officers in a manner that did not create any transparency or accountability. Is that fair?
That's a fair statement.
Okay. Thank you. And I see that neither Mr. Allen or our other councils here, so we'll ask council if you have any redirect.
I do have just a few, Mr. Chairman. You testified earlier that you were unaware of what the penalties were for unauthorized use of a purchasing card to make a transactional purchase of this nature. Is that correct?
Yes, and specific to purchasing gift cards without proper approval.
But as unauthorized use of a purchasing card generally is a criminal offense, isn't it?
I think it would depend on the nature of the unauthorized transaction.
My recollection is that failure to obtain approval of the auditor for a purchasing card purchase is a felony in each instance.
Is that correct? Your understanding would probably be better than mine.
And my understanding of the constitutional duties of the Supreme Court are that they have the entirety of oversight of the courts. While they are a judicial body, they do have an administrative role.
That's correct.
And they maintain an administrative office of the courts.
That's correct.
And the 5 justices, superintended by the Chief Justice in his or her capacity, oversee the operation of all of the subordinate courts.
That's correct.
And have ultimate responsibility for the activities of those courts.
That is also correct.
And they meet in their administrative meetings. They often deal with fairly arcane and what we would consider perhaps even trivial matters of those courts, sometimes down to the salaries of the subordinate officials in those courts.
It's quite possible.
And I believe that they are responsible out of, as we had testimony earlier from Mr. Allred with their central warehousing office, that they equip the subordinate offices and courts with all of the equipment and materiel that they need to do their job.
To some degree, yes, but not fully outfit the lower courts.
But they are responsible for seeing that those lower courts are indeed outfitted and able to proceed to business.
Yes, that's correct.
And so ultimately, when there is a purchasing card issued to an entity such as the Adult Probation Office, which is overseen by the court, the use and authority of that card, the ultimate authority and use of that card rests upon the rules and oversight provided by the Supreme Court.
That's correct.
And Exhibit number 16 was a series of guidelines which were promulgated by the Supreme Court of Appeals of the state of West Virginia for the use of those subordinate bodies.
I believe so, yes.
And those subordinate bodies, while they may have explicitly followed the provisions that are set forth here, did not follow the larger procedures which were set forth in the auditor's guidelines to obtain prior approval prior to the purchase of these so-called high-dollar gift cards.
That's correct.
I have nothing further, Mr. Chairman.
Starting back on the left side, Delegate Foster.
I was looking here in the report on page 8 where it's talking about 2016 and 17, and what I'm wondering is, so this went on for at least 2 years without anybody noticing there was an issue, and what I'm wondering there is there not, if it has to be approved, and as council laid out, the possibility of a felony if it was not approved before the purchase was made, how do we go 2 years without catching it?
It's a good question. I don't have the answer.
And along those lines, is there not a standard for, hey, there's purchases here of gift cards for this amount, and it was not, and whenever you see there's a large purchase on a P card, to say, hey, was this approved or was it not? Is there no flagging system to say, hey, here's a purchase that wasn't approved, or and also who is responsible for that?
Internally at the court, I do not know if there was a procedure to flag such large transactions. From the meetings we held with Kanawha County Adult Probation representatives, they told us that it was simply a misunderstanding. They weren't aware that they required such prior approval from the state auditor's office to make those purchases. Now to the question, if it's, why did the state auditor's office not flag those transactions? I don't have that answer either.
Okay. And so, but it would be the state auditor's office that should have caught that something was not approved before purchased?
That's a fair statement, yes.
Okay. All right. Thank you.
Delegate Savonia, questions? Delegate Bushkin.
Thank you, Mr. Chairman. You stated earlier the only cases where this wouldn't be paid for by the fees of the participants would be in a juvenile drug court. Are there any instances of participants in juvenile drug court getting gift cards?
I believe there was one noted when we looked into all gift cards being purchased by the drug court incentive programs where there was at least one issued to a juvenile, yes.
One card to one juvenile?
That I'm aware of. We did not cross-reference these particular cards to the particular courts that they were issued to.
Okay. Well, I see that the Legislative Auditor's Office made recommendations to deal with this issue. I think they're perfectly fine. Thank you.
Back to the third row. Any questions back there? Okay. Delegate Hanshaw? Delegate Flashauer? You're looking like you want to get out of here, right?
I think I may be subjected to a few more questions coming up. So
All right.
I'm okay. I'm hanging in here.
I just want to be sure. We had $105,000 of somebody else's money, whether it's the taxpayers or the taxpayers who are drug court participants, and we can't say where any of it went.
No, and that's the difficulty with this is the lack of accountability and transparency to ensure that all the money is collected from the participants was actually spent out in accordance with the regulations governing the incentive program.
So we suspect that some of it may have been spent for the purposes it was intended, but we can't be sure.
I wouldn't say suspect, but the likelihood exists.
And that's based on what?
The lack of proper procedures to provide the accountability necessary to account for the dollars spent off the large denomination cards.
Maybe I didn't state my question clearly. We don't know for sure that this money was spent for the purposes it was intended. I mean, for instance, somebody that bought a large P card could have spent it.
Yes, due to the system in place, if someone purchased a $1,000 gift card and there isn't itemized receipts to account for every dollar that was spent on it, there is a possibility that someone purchased an item for personal use.
Or a lot of items with $1,000, right?
It's possible, yes.
Thank you. Anything further for Mr. Robinson? He's had a long day. Thank you, Mr. Robinson. We'll start on the third. Are you? Third report. Is that you too?
Third report's me, yeah. It'll be all right.
Let's see how far we get on this one. It doesn't sound like it's going to take too long.
No, as long as it takes, I'm perfectly fine. Jeremy.
All right. Counsel?
Thank you, Mr. Chairman.
You don't need this reminder, but just in case you do, you're still under the same oath.
Thank you, sir.
All right.
Mr. Robinson, we are now going to move to the third report. I believe we briefly discussed that earlier this morning, that there have been 3 reports completed with respect to the Supreme Court during this calendar year. Is that correct?
That is correct.
The third report that I have is entitled, at least in part, Reappropriated Fund Balance Analysis. Is that correct?
That is correct.
Turning to page 2 of that report, could you please tell the committee how the legislative auditor first became aware of concerns with respect to the spin down that has been referenced in this report?
Yes, we noted issues and discussions in the administrative conference minutes of the court concerning questions of the spend down and where the money had went.
And I believe in the first paragraph of that, there's also an indication that in reviewing a memo that was written by Justice Lawfrey, in which he was responding to some questions regarding his usage of court vehicles, that he had mentioned this as well. Is that correct?
That's correct.
And just for ease of reference, not that I will go to it, it's my understanding from the exhibits we looked at earlier today, that memo is exhibit number 6, that Justice Lawfrey, if you could please just confirm that.
That is correct.
Okay. With respect to this, it is my understanding, and this would be on beginning on page 13 of this report, that a memorandum was prepared by Mr. Canterbury back in November of 2016 regarding at least some of the issues contained in this report. Is that correct?
That is correct.
If you could, actually, let me back up there. It is my understanding that and we're back on page 2, that there was a meeting that was held with the, at the time, current administrative director and the director of financial management to discuss those, the reappropriated funds. If you recall, were you part of that meeting?
I was, yes.
And who at the time was the administrative director?
Gary Johnson.
And what about the director of financial management?
Sue Racer Troy.
Okay. And I believe if you could just explain to the committee the concerns that you had and what you were able to determine. And by that, I'm specifically still staying on page 2 and trying to figure out how you were able to determine how the funds were accumulated.
Well, we actually couldn't exactly determine how the court or why the court had accumulated that amount of money in the time frame that it had. I think beginning in 2007, end of that fiscal year, the court reappropriated approximately $1.4 million, to which that balance grew to $29 million in 2012.
And I see you referring to a graph. I will now ask that you please refer to that graph. I believe it is located on page 3 of this report. Does that provide the trend of the yearly reappropriated funds for the Supreme Court?
Yes, it does, for the years of 1997 through fiscal year 2018.
And I believe you just indicated that in 2012 that was at a little over $29 million. Is that correct?
Yes, that's correct. And on page 2, we identified these specific categories where such funds were reappropriated from the prior year.
And by 2016, what was that balance?
$333,000 or $333,514. So just a little over $333,000.
The report beginning after that graph, beginning on page 4, does go through the fiscal years and does some analysis and provides information about the reappropriated balances in those years. But if I could, before we get to that, move forward to Mr. Canterbury's memo that begins on page 13 of this report. Could you please tell the committee how did this memo come about? Why did Mr. Canterbury, your understanding of why Mr. Canterbury prepared this memo?
This memo was prepared by Mr. Canterbury in response to a request from Justice Workman, who asked that he prepare it to explain how some of that $29 million was spent down to the balance it was currently at that date.
I believe in the last line of the first paragraph, he notes, in brief, she, I believe referring to Justice Workman, wants to know where the money went. Is that correct?
That is correct.
Going through, and I understand this is a several-page memo, not to go through each and every paragraph, it is, if you could please just summarize your recollection of, generally speaking, what this memo says with respect to what happened and how the decision was made with respect to spending.
In Mr. Canterbury's words in this memo, there are several reasons cited for the spend down. Some of them include raises that were given to justices, judges, and magistrates, renovation projects that were needed in their City Center East location here at the Capitol, amongst various reasons, but they also did cite some reasons concerning the concern over a potential sponsorship by the legislature of a constitutional amendment that may take away their budgetary authority.
And I believe on page 13 in the second full paragraph, beginning with the third sentence, it notes, and there was a decision by the court to ask for lower appropriations during the most recent fiscal years due to growing concerns that key Senate leaders were angered by the excessive amount of the court's surplus funds, as they styled it. Is that correct?
That is correct.
In the next paragraph, I would ask you to look at beginning on the second line, it starts with but. It notes that the court approved. Mr. Canterbury notes in his memo that the court approved each and every one of those appropriation requests with the understanding of the major issues that the court was facing when the court approved those requests. Is that correct?
That is correct.
Does he cite one of those major issues that the court was facing as the threat of a successful constitutional amendment to take away the court's budgetary independence if the court had continued to have those large funds at the end of each fiscal year?
Could you redirect me to where you're referencing? You said page 13?
No, on page 13, third full paragraph, the second line down, in the middle of that, it starts with but that the court approved.
And your question again was? Apologies.
Oh, no problem. That the court decided to make those expenditures knowing what issues the court was facing at the time, and that was one of those issues he identified was the potential constitutional amendment to take away the independence of the court's budget.
Yes, in Mr. Canterbury's words in this memo, that's correct.
And again, I will not belabor all of these, but similar to what your report did, then Mr. Canterbury went through year by year to provide some explanation for the reappropriated funds. Is that correct?
Yes, this memo actually had a brief cover letter that described that the request from Justice Workman was to try to describe the spend down in bullet point format as briefly as possible. So the fiscal year summaries provided by Mr. Canterbury in his memo does not go into great detail, but it does try to capture the reasoning behind some of the spend down.
Okay, and he did note that he was asked to keep it brief, so he put it in bullet format for that reason.
Yes.
Okay. And with respect to those years, again, there is notation as to how some of the money was spent. And I believe, and I'm going to now refer you back, still saying on Mr. Canterbury's memo, on page 13, let's see, the third paragraph, the first sentence that I had not previously read, I believe he notes that he felt it was necessary to point out that not only is every dime accounted for in Director Sue Racer Troy's electronic files, that he believed that every dime was accounted for. Is that correct?
That is correct.
And now I'm just going to ask you some general questions with respect to that. Has your office, is this investigation still ongoing?
Absolutely. There is a tremendous amount of transactional data that we will have to review to ascertain the specifics of this spend down.
Okay. And when we continue to talk about the spend down, we're still talking about the spend down where what happened between $29 million in 2012 and approximately $333,000 in 2016.
That's correct.
And again, and I might have just asked you this, and if I did, I apologize, that investigation is still ongoing.
Yes, that investigation is still ongoing.
Okay. If you could just, to the best of your ability, and again, I understand Mr. Canterbury was asked to be brief, and I'll ask you to be brief as well. If you could just generally, again, to the best of your ability, try to summarize for the committee what you understand happened between 2012 and 2016, just up to this point. Would
you like me to cover specific categories in general?
If you can.
Okay. And going through our analysis, ultimately our report somewhat mirrors Canterbury's attempted analysis, and I don't mean to say attempted as to be derogatory towards his analysis. We just tried to be more specific. But given the amount of data we had to review, essentially we were able to go through fiscal year to fiscal year from fiscal year 2012 to 16 and identified specific categories of expenditures that saw a significant increase in spending over the prior year's expenditures. In fiscal year 2012, those categories ultimately almost every year of this review from our office included an increase in payroll. I think the total increase in payroll in 2012 was $12.4 million, but we identified various categories. Would you still like me to go through the various categories? I'd be happy to. Okay. So for 2012, we saw a total increase in payroll expenditures of $12.4 million over the past year. Then we noted travel, saw an increase of $587,000 over the prior year. Telecommunications, $582,000 over the prior year. Leasehold improvements, $873,000. That's an approximation. And computer equipment, $361,000 over the prior year. For fiscal year 2013, again, we saw payroll-related expenses increase, this time $900,000 over the prior year, but that also takes into account the $12 million that had increased the year prior to that. Other areas we saw increases in expenditures included contractual services, which increased $1.58 million over the prior year, computer services $922,000 over the prior year, routine building maintenance $505,000 over the prior year, office equipment $330,000 over the prior year, and consulting for capital asset projects increased $725,000 over the prior year. All these are approximations. Then moving into fiscal year 2014, payroll expenses again increased $2.4 million over the prior year, which is a trend of 3 years in a row of increases. Other categories, rental expenses for real property increased $376,000. Contractual services increased $486,000. Travel increased $909,000. Computer services increased $359,000. Attorney legal service payments increased $1 million. Miscellaneous equipment purchases increased by $272,000, and contractor payments for capital asset projects increased by $1.25 million. And computer equipment again increased $409,000 in fiscal year 2014. Moving into fiscal year 2015. Total expenditures actually decreased in this year by $1.6 million, but due to the increases in the prior years, the reappropriate balance was still depleted. Payroll expenses increased $1.45 million, and the only other area we noted that saw a significant increase over the prior year was contractual services, which was increased $2.7 million over the prior year for a total expenditure amount of $4.99 million. And that's what carried over the $333,514 into fiscal year 2016. And then by the end of fiscal year 2016, while we did see some categories have increases in expenditures, overall, based on the appropriated amount that the court had received, their appropriated balance didn't reduce, it actually grew at the end of fiscal year 2016 to $1.24 million. And that should summarize what you were asking.
With respect, and again, I know you have indicated that your investigation in this is ongoing. Are you investigating all of these different categories with respect to the increase in salaries, contractual services, the categories that are listed in the report now, or how is that investigation going? What are you looking at?
Our initial focus will be to try to identify specific expenditures within the categories we've identified of having a significant increase over the prior year. But also it is our intent to try to identify expenditures related to the renovation projects and to possibly weed out those infrastructure related renovations versus those more office furniture, decorations, etc., and try to identify expenditures related to that. So categorically, I can't say that we'll focus specifically only on these categories identified in this report, but for us it was a good start and it was a good way to get some information out to alleviate some concerns over what areas potentially saw an increase.
And that's generally what this report number 3 does, shows the general areas that saw increase over those years.
Yes, essentially our analysis was just a categorically comparative analysis of specific expenditures over the prior year, and some categories saw a decrease. So it's not to say that, as you'll see in this report, if you added up all the increases over the prior year, it may exceed the amount that the excess fund balance was reduced. But that's because when you net it with the other accounts or the other expenditures that actually saw a decrease, we get to the amount that we got to.
Mr. Robinson, I don't believe I have any further questions for you.
Thank you.
Thank you, Council. I'll start on the right side at this point and begin with front row, right side. Delegate Holland, do you have any questions? Delegate Lane.
Thank you, Mr. Robinson. I'm looking at the post-audit analysis of expenditures by the Supreme Court, Table 1.
Okay.
Now, looking at 2012, the appropriation was $120,483,000.
Correct.
And the total available was almost $150 million.
That's correct.
And the total expenditure was $126 million. Now, I thought that you could only spend what had actually been appropriated. And that would be $6 million more than the actual appropriation.
The $29 million are carryover reappropriated general revenue funds from prior years. So that would also be allowed to be spent, and their total available is what they can spend from.
So when you say appropriation, it's really the same as the total available.
No, for fiscal year 2012, the court was reappropriated $120.483 million worth of new appropriations from general revenue funds that year. It had a balance of $29 million, a surplus balance, if you will, that was carried over from prior years.
And I thought that surpluses had to then be included in the appropriation to allow the body to spend that amount of money in that fiscal year.
That may be the case for typical state agencies, but the Supreme Court's its own branch of government, and it's my understanding that what they request is what they get, and they are allowed to spend from their reappropriated balance.
And we don't have a requirement that we appropriate that amount of money?
Not to my knowledge. It's my knowledge that the Supreme Court has its own budgetary authority to request what it needs.
Okay, thank you. That's all I have.
You're welcome.
Second row. Third row. Oh, I'm sorry. Delegate Byrd.
Thank you, Mr. Chairman. Mr. Robinson, you said there's still more data that you are compiling regarding this.
That's correct.
Has your office set a timeline on when to release that data?
Not at this time, but it is priority for our office.
Thank you.
Delegate Miller.
Thank you, Mr. Chairman. In regard to the 2016 memo issued by Mr. Canterbury, were you able to uncover at any point after that memo was issued that memo was put in question by any member of the court, any justice, or anyone else, or any personnel once that investigation was brought forth, or those allegations are levied?
Chief Justice Workman adamantly denies the accuracy in statements made in Mr. Canterbury's memo, with particular regard that the focus of the spend down was to avoid a constitutional amendment taking away their budgetary authority. We spoke with Mr. Canterbury regarding this memo subsequent to discussing it after our May report, to which he attested to the accuracy of the memo and the fact that those conversations did occur as he described.
Was that by conversation where she protested, or did she issue a document, and if so, when?
She verbally disagreed with the statements made in his memo subsequent to our May reporting at the post-audit subcommittee. She may have made the statement as well in writing in response to a report. I'd have to look back into the appendixes. But she has, at a very minimal, had made a verbal disagreement to the memo.
And that was answering to your inquiry?
No, we made mention at the end of the second audit report to the post-audit subcommittee of what the upcoming report subject matter would cover. And I made mention of this memo by Mr. Canterbury. and the statement made. The question was then posed to her, I believe, by the Senate President regarding this memo and the spend down, to which she adamantly denied that the court, her, or any other justice discussed the need to spend these funds down to avoid a constitutional amendment.
And that was in 2018 that she made those
Yes, it would be available in the video archives of our post-audit subcommittee meeting following that May report.
Is there any kind of documentation or evidence to show that there was any kind of disputing of his memorandum between 2016 and the inquiry by the Senate President in 2018?
So are you asking, is there any documentary evidence that would support whether or not there was this dispute had before she made the statement after our post-audit subcommittee meeting?
Correct.
No, we have not found any documentation to show that this was disputed prior to her statement made at the May 2018 post-audit subcommittee meeting.
So that's nearly a 2-year period of no mention of his allegations until it was brought to light in public.
That's an accurate statement.
Okay. He makes reference to unanticipated construction and furniture purchases, along with other purchases totaling $12 million. Are you able, or are you in the process of trying to delineate specifics on that allegation?
Yes, we are in the process of doing that, yes.
If, and this might be a general question, but if the legislature is not appropriating more than what is said to be needed to operate the courts in a year, it seems like, according to the graphs and the information that's been provided, they continually make money, for the lack of a better description. How do they generate and come up with a surplus each and every year if they're operating according to their own numbers as to what they need? Or if you can answer that.
I can't answer the why the court continues to accumulate excess funds at the end of the fiscal year, but it was mentioned during the June post-audit subcommittee meeting that the court would be happy to build itself a surplus, a somewhat rainy day fund.
Do you have any knowledge if the Supreme Court has a standalone or any standalone bank accounts that are outside the purview of the state treasurer?
Not that I'm aware of.
Would that be proper accounting procedures for the state of West Virginia if the Supreme Court did have its own mechanism to receive funding absent the state treasurer's office?
Yeah, I believe there would be some issue with that. At a minimum, I think any outside bank account operated by any state agency or branch of government should be reported to the treasurer's office.
Who ultimately has the authority to authorize or direct to expend increase in expenditures of the excess fund? Who's the ultimate responsible person for that, or persons?
I believe that responsibility would fall in the administrative office of the court and the justices.
And the justices, or the justices?
The justice and the justices.
Has that where the authority has always been, or has it changed over the years, even since 2010, let's say?
I can't speak to the change over the years.
In regard to their normal expenditure of funding, do they have a particular procedure, purchase orders, bidding, as we would be familiar with in state government?
The Supreme Court of Appeals of West Virginia is exempt from the purchasing divisions. So they do not have to follow the same guidelines typical state agencies do with regard to the purchases they make.
Do you know if they do even remotely follow any type of generally accepted purchasing procedures?
I am aware in many instances that they do attempt to try to follow those procedures to ensure that they're getting the best bang for the state dollar, but there are also instances we've noted where they have not.
If you know, are excess funds spent under any kind of different rules, internal rules at the Supreme Court than regular budgeted items?
I'm not sure. I know the court does allow, it is allowed to maintain a discretionary fund, but the direct nature of that fund I'm not aware of.
Is there an ultimate authority who actually physically signs off on spending?
To my knowledge, the administrative director of the court ultimately signs off on the spending.
That's based on a vote of the court, an authorization by the court itself?
I believe there's some thresholds of dollar amounts that can't be exceeded or decided upon by any one individual at the court without it having to be brought before the justices and the administrative conferences.
So once that threshold is met, the justices have the responsibility to direct or authorize spending?
I believe so. I'd have to look into that further.
Are you aware of any other reference letter other than Mr. Canterbury's that had been issued as to why the allocated fundings had been spent down?
Not to my knowledge.
I think that's all I have. Thank you, Mr. Chairman.
Delegate Robinson.
Thank you, Mr. Chairman. Mr. Robinson, how long did the entire spin down occur?
You mean from the $29 million to the $333,514?
Yes, sir.
It happened between fiscal year 2012 and fiscal year 2016.
Okay, looks like the big drop was actually probably 14 to 16. Looks like they dropped a little less than $15 million over from 14 to 16.
Between fiscal year 2012 and 13, it looks like it dropped approximately $7 million. Between 13 and 14, approximately $7 million. The greatest reduction in this appropriation rollover was between fiscal years 14 and 15, which saw approximately $13+ million in increased expenditures.
I asked you this question earlier. I don't think you knew, but what year was Justice Lawfrey elected?
I'm uncertain. I believe 2012.
Do you know who the Chief Justice was from the time period 14 to 16?
I do not.
Okay. Would the Chief Justice have approved the budget on an annual basis, and the whole court approved the budget following the lead of the Chief Justice at that time?
I'm unaware of that.
Does the court approve the budgetary item in an annual basis? I'm
unfamiliar with the court's internal process for formulating its budget.
Would counsel be able to answer that question, Mr. Chairman?
I don't think council can answer that question. That's something we're trying to find out.
Of who approves their budget? Is that we're unaware of how they approve their budget? Okay, thank you. Wow.
Now to the left side. Delegate Fast, any questions?
Just following up on what my colleague just said. So when the Supreme Court makes its appropriation request, we're not sure how that comes down the pike?
No, I'm not directly familiar for each instance of each appropriation request, how they formulated the amount in that request.
Okay. And I see on page 10 of your report, it's projected that the reappropriation balance for 2018 is going to be all the way back up again to $19.2 million. Since this report was finalized not too long ago, do we have any definites on that yet?
It has kind of reached the close of the fiscal year, so it is possible we could ascertain that information now, but at the time of the report, that was the estimate that was actually noted in a memo between, I believe, the administrative director and the director of financial management office for the court, that the balance would grow to 19.5 by the end of this year.
Okay. Are there, I know a lot of fines and court costs and things like that go into the coffers of the court system, and I'm assuming a great deal of that ends up under the jurisdiction of the Supreme Court. Do you know if there are any identifiable fees that just keep feeding the Supreme Court to make it grow so exponentially financially?
I don't believe our analysis includes any special revenue funds. So I don't know that collected fees are part of this. The amounts we are noting in our analysis includes appropriated funds from the General Revenue Fund on top of any funds that remain in the court's balance at the end of the fiscal year.
Okay. Well, it seems like the appropriations are not necessary, in fact, have decreased in recent years, last 2 or 3 years at least, but yet we're looking now at another surplus of $19 million. So it seems like there's some infusion of funds from some other source besides appropriations when appropriations have been decreased. And if you can answer that, I understand. I'm just...
No, I would draw your attention to Table 1 on page 6 that kind of breaks this analysis down. The amount appropriated from the legislature and from the General Revenue Fund to the court has increased consistently each year from 2012 up until 2017. The current fiscal year appropriation request matches that of 2017. But if you'll note in the next to the last right column, total expenditure amounts, you'll see that total expenditures increased every year up until 2015, when it decreased slightly over the prior year, or under the prior year. 2016 expenditures were $138.6 million, but then in 2017 those dropped another $4 million. The anticipation of the growth in the year-end balance for 2018 would not be attributable to any outside funds coming in. It's a reduction in expenditures.
Okay. So mostly legislative appropriations then?
Yes.
Okay. Very helpful. Thank you. Is the audit report alleging malfeasance on the part of the Supreme Court as a whole or any particular justice?
Our audit reports do not... and I forget how you just phrased it. Sorry.
Malfeasance?
No. Are we suggesting that? No. It is not our place to suggest it. It's our place to just provide the facts objectively and draw a conclusion from those.
So the section of this report is basically legislature take note, maybe you're giving the Supreme Court too much money, or?
Yes, essentially this report's mostly informational to provide some background over the concern of the spend down to what we could provide up until the May interim.
Okay,
interim,
and
excuse me.
Just before I pass the mic, we've heard about some of the justices' offices being renovated at a pricey amount. Does that, in your report, implicate a justice for maladministration or malfeasance? Something along those lines.
I wouldn't like to make that speculation. I think that's a decision for this body.
Thanks.
Justice Elliott Foster.
Thank you, Mr. Chairman. My questions are going to kind of revolve around page 7 to page 9 of this report and the changes year to year. Now these, did I understand you correctly earlier, are these expenditures from the appropriated and the reappropriated, or is this just from what was spent down of reappropriated on these pages here, 7 through 9?
On these pages, essentially, we've identified, and that's the difficulty in the tasks that we're trying to accomplish. Essentially, all expenditures are spent out of the same pot. We're looking at the General Revenue Fund appropriations to the court specifically. We're not looking at special revenue funds, so this would be the appropriations received in any given year, plus whatever remained from the preceding year. So all these expenditures are coming out of the same pot. For us to put a finger on one particular expenditure and say this is attributable to the spend down is nearly impossible.
So you're just looking at what increased over those years. And that's what I wanted to ask you about. First of all, what is contractual services defined as? Like, what does that entail?
And forgive me, essentially this is how the OASIS and the FIM systems would break down categories of transactions by object codes, and there is a definition assigned to that. Contractual services essentially is any work performed by an entity or individual for which there was a contract dictating those services.
So would that be like, because I see it's also broken out into attorney, legal services, and payments. Is that part of the contractual services, or is that something separate, like for attorney and legal work?
I wouldn't be comfortable answering that now. That's kind of the purpose of our continuation of this work, is while these categories are very broad and subject to human error in how they're applied in terms of the object code of the specific transaction, we need to review them individually to determine what exactly the transactions were for, to really be able to speak definitively whether or not they do meet the criteria for that category in of itself. So I wouldn't want to answer that without a continuation of this work.
Okay. And then the other one I wanted to look at was travel, because as it says in 2012, it went up to 1.5 million, which was an increase of basically 5 million.
An increase of 587,000 was the increase.
Or, I'm sorry, of 500,000. So in 2011, it was 1 million, and then if you go forward to 2016, it went from 1 million to 3 million in just 5 years.
Yeah, we also noted the increase in fiscal year 2014. It was somewhat significant. It increased 909,000 to 2.3 million in fiscal year 2014. It may have not been noted in fiscal year 2013 because the amount of expenditure increase over the prior year wasn't as great as others that we identified. But you are correct in stating that from 2012, those expenditures increased it from roughly 1.5 million to 3 million in fiscal year 2016.
Well, from 2011, it would have been from 1 million to 3 million. So
yes, no, that's correct.
It tripled over a 5-year period. At the same time, we have these issues with the vehicles.
That's correct.
All right. Thank you.
Delegate Sabonia.
Thank you, Mr. Chairman. On page 8, under fiscal year 2014, it indicates that for the real estate rental expenses for real property, it increased 375,000 or more, almost 376,000 from the previous year. And they say that it was because of the renovations to the Court City Center East and the Capitol. Have you all looked to see exactly how that money was accounted for, if it was dollar for dollar? And also, is the Supreme Court real property under the jurisdiction of the Real Estate Division for accountability?
The second question I can't answer at this time, and the specifics of these expenditures and how they relate is a product of our continuing work, so I can't answer the first question either.
Okay, and I'm looking at the fiscal year 2011. It says at the end of 2011, the court carried over approximately $29 million into FY 2012, so that surplus was in existence in 2011?
In 2011, I believe, at the beginning of fiscal year 2011, the excess balance was somewhat below 29 million. I don't have the information directly in front of me. But by the end of fiscal year 2011, going into fiscal year 2012, it was 29 million that the court had accumulated in unused funds.
Thank you.
Going to the second row. Delegate Harshbarger.
Thanks again for being here. Thank you, Mr. Chairman. On page 8, there's a comment in there at the top. It says the legislative auditor questions the court spending on renovations to the lease space at City Center East. And it goes on to further say it benefits the lessor. Is it typical practice for the state to renovate a building they're leasing, or would that be up to the landlord?
I can't speak to whether or not it's a typical practice of the state, but the purpose of us calling that question was we've noted several memos that indicated there was significant spending on renovations at that location, and I do believe it was Chief Justice Workman in at least one of those memos that expressed concerns over the fact that those improvements paid for by the court would at the end of the day benefit the building owner and not the court.
Yeah, because that looks like it was in 2013 and 2014 those renovations took place. Okay, that's all I have. Thank you.
Delegate Hanshaw.
Yes, thank you, Mr. Chairman. Mr. Robinson, did your office have an opportunity to review any kind of documents that I'm going to characterize as what would be minutes of administrative meetings of the court?
Yes, to which all the minutes that we were provided from the administrative conferences of the court were provided to council.
Okay. I'm interested in whether the decision that's characterized in Mr. Canterbury's memo as a decision to, quote, spend down the money was a conscious decision of all those in favor of spending down the money say aye, or was it more a series of conversations over time that, well, we've got all this money, let's spend some on this, let's spend some on this, let's spend some on this? Can you characterize that?
Yeah, that's an excellent question.
Extremes?
We actually reviewed all those administrative conference minutes to determine whether or not the conversation, as noted by Mr. Canterbury's memo, had occurred as he had stated it did, to which we were unable to find any evidence within the administrative conference minutes of the justices of the court that that matter was discussed the way Mr. Canterbury had described it in his 2016 memo. There were vague discussions over budgetary issues and the needs for raises, renovations, et cetera, but nothing in specific relation to the need to do so in regard to any threat of a constitutional amendment.
Okay, thank you.
You're welcome.
That's all, Mr. Chairman.
Delegate Fleischhauer.
Thank you, Mr. Chairman, and thank you again for continuing to be here at this late hour. One of the solutions to any problems that have been raised here is the passage of the constitutional amendment. Would you agree?
I cannot agree that that's a solution. That's the policy decision that my office would not want to make.
Pardon me?
I'm confused by your question, but you're asking if the constitutional amendment would be a solution?
Yes. Right now, the court has authority over its own budget. And if there are concerns raised about the way they're spending their money, those concerns could be alleviated by giving a great amount of oversight to the legislature, like the legislature has over the executive branch.
If I answered that question, I feel like I'd be speculating on a policy decision that's not my authority to make.
Well, I guess there are recommendations in here. And we've passed it. The legislature has made it. So I'm not asking whether you agree or disagree. You are outlining solutions. Wouldn't you agree that one of the possible solutions that could prevent this from happening in the future is the passage of that amendment?
It's a possibility, but I don't want to say that definitively. It still seems to me that my answer would be a matter of opinion.
But you can make recommendations about everything else in your 3 reports.
We make suggestive recommendations to the legislature concerning the passage of laws, revisions to legislation or statute, but we do not direct the legislature in those decisions themselves. And it seems to me what you're asking me is if I would feel that the constitutional amendment would be a solution to this problem identified in this report. And I simply can't speak to that, whether or not it would be a solution or not. There could be other measures that could alleviate the concerns as well.
Do you want to speak to them?
We have not completed our work in this area yet either. So there is a lot of research we still have to do concerning these expenditures, the cause of the spend down, et cetera.
Okay. One of the things I believe you talked about, and maybe it was Mr. Canterbury would talk about it, is mentioning changes in payroll. And in these categories that are increasing, payroll is not mentioned.
It's just not noted in the categorical tables. It's actually noted in the body of each of the preceding paragraphs.
That's what I thought.
Yes.
Okay. So one of the things that that Administrator Canterbury talked about was the pay raises that were passed by the legislature. And I wondered, another thing that I recall happening in this time period was the passage of the Juvenile Justice Reinvestment Act. I think that was in 2013. And part of the rationale behind that is that we need to keep juveniles out of facilities and prevent them from being, looping into the criminal justice system. And so that the idea was if we invest early in these young people that there'll be a long-term payoff. When you're doing your audit, will you be looking at that? There's the Pew report that we based the passage of that legislation on, said that that's why states are doing that all over the country, so that there'll be more spending within the courts and less into the criminal justice. Is that something you will be looking at when you do your legislative analysis?
We don't have any specific plans to look at that, but if it does come up as a component of the expenditures that we will note as causing or being attributable to some of the spend down, or an area that saw an increase in expenditure over the prior year, there is a likelihood we will, but I can't say definitively that we will.
I think that would be valuable to look at that. And also, I'm not sure I remember this correctly, but the drug courts were on a pilot project basis and then they became statewide. Do you know if that is part of the increase in payroll or contractual services, since a lot of those are nonprofits?
And I'd reference you to Mr. Canterbury's memo. We can't definitively state whether or not that is the cause because we haven't looked into it further. But Mr. Canterbury does note in his memo that the mandate that all of the counties of West Virginia operated drug courts was a significant increase in expenditure that attributed to some of the spend down, yes.
Okay, thanks.
You're welcome.
Thank you, Mr. Chair.
Mr. Robinson, just two areas that I want to go over. The Canterbury, excuse me, November 7th memo. How did that come into your all's possession?
I think when we had ran across the issue of the spend down and reviewing memos regarding Justice Lawford's use of the court vehicle, we became aware of the concerns within the court. I can't be specific, but either we requested this information from the court in general in relation to any memos that discussed the spend down of the surplus, or it could have been indicated to us by Mr. Canterbury himself in a prior conversation in relation to this concern.
I guess the point of my question is in the way that you received this memorandum, was it received with a quantity of other information in a chronological order that would help you determine whether or not this memo was actually disseminated on November 7th, 2016 and to the justices, or whether it perhaps was created at some later time?
The memo itself was provided to us in an informational request to the Supreme Court. It was not provided by Mr. Canterbury, if that's helpful to you at all. I do believe that in specific regard, and excuse me, I'm not really sure exactly how it came to be in our possession through what particular request, but as I described, it was either part of a larger request or it came specifically from a request to the court regarding the memo itself.
So basically your requests were, and as opposed to you going through files, say in the court, you were basically asking for information. They extracted that information and provided you the information.
Yes, the court provided this memo, and again, I can't speak to the request that resulted in us getting this memo. I can try to find that and provide it, and it's most likely in the files we provided counsel, but I can't speak definitively to why exactly we received this memo.
And the point is, I would assume that if it was in fact delivered to all the justices, it would probably be in their individual files, and it would verify that in fact this is what he prepared at that time. It might not verify what he says, but it certainly would verify the chronology of this. Would you agree with that?
That'd be correct. And I would also like to note that when we were asked to be provided this memo, when it was provided to us, there was no other information provided regarding the memo's validity or whether or not it had actually not been distributed to the justices or had it.
So at the time you received the memo, was Mr. Canterbury still employed with the court?
No, he was not.
So the court, it was extracted from documents in the possession of the court as opposed to from Mr. Canterbury?
That's correct.
Okay, thank you. I just want to go back to this contracted services category because this really jumps out at me. 2013, it indicates it was about 1.59 million over the prior year, which tells me that the prior year, our base year in 2012, was only about $187,000.
That's correct.
So it grows that year to 1.7, and 2014 it grows to 2.255, and then in 2015 to 4.99, and then in 2016 to 6.5, basically. So if my math is correct, that category grew over 35 times from the base year.
That's correct.
So is there any explanation, a reasonable explanation for that kind of growth?
The court has explained it as there was some e-filing that they were doing that attributed to some of the increase in that category. But beyond that, to speak in any specificity, I don't have that information. That's the purpose of our continuation of this work.
Yes, I'd certainly emphasize the need to really dig down in that, because that jumps out probably more than any other category.
Correct, sir.
All right, let's see, council, any redirect? Rather than go down the rows, raise your hand if anybody has a follow-up question. I don't see any. I think you really are off the hook this time. Thank you, Mr. Robinson. All right, to the members of the committee, combination of the retirement of Justice McKetchum and the fact that we worked late tonight probably has shortened our agenda by a day, I would say, and say it's pretty safe to assume we'll wrap up tomorrow late afternoon. We will disseminate this evening. We're going to meet with staff after we adjourn tonight and try to get a sequence of our witnesses tomorrow. We'll disseminate an email so you'll know who we know are coming tomorrow and what to expect. In the meantime, hope you're able to get some rest tonight. I'll entertain a motion. We adjourn until 9 a.m. tomorrow morning.
Committee recess.
Recess till 9 a.m. tomorrow. All in favor will say aye. Aye. Opposed, no. Motion carries. See you all in the morning at 9 a.m.